hope this is working. Somebody's going to tell me if it isn't, I'm certain. But good morning, everybody. I'm Scott Peterson, and I'd like to say happy to be here with you. I am happy to be here with you, as I always am happy to be with you guys. But, we're all living in a strange and difficult time right now, and I wanted to put this together over the last couple of weeks. Obviously, I've seen a slight increase in the volume of hotline calls and other inquiries from you guys all over the state related to the coronavirus and the implications of coronavirus and so on and so forth. And so I've been kind of, keeping a list and commonly asked questions is what I'm basing this on and trying to give you guys some best practices and some other things to be thinking about. So I've got a PowerPoint that I'll put up in just a minute or two so that you can see that as I kind of walk through some of my thoughts. As the screen before indicated, if you're going to participate or have questions, there's a Q&A box at the bottom of your screen there, I think. I have a little bit different view, I think, than you do. But there's a Q&A box. Ask questions, on that throughout. And I'm going to go through kind of my thoughts, and then I'll be able to go in and I can see the questions as they've come in, and I'll try and get to as many of those as possible. We're going from 10:30 to 11:30. If we go beyond a little bit, I think we're okay there. So I'll try and get your questions all answered to the extent that I can. Couple just housekeeping and other notes. This is our first time doing this. And so, 3 weeks ago, I'm not even sure I knew what Zoom was. And here we are. I feel like I've been sort of living on it over the course of the last few weeks. And so be patient. We're doing the best we can. I have the co-host up there with me is, I just want to mention them and make a quick comment about car staff generally. But Jonathan Griggs and Lisa Hansmeyer are, that you'll see maybe on your screen, are the two co-hosts of this thing today. And Jonathan's our Director of Technology, and he's got a really long title because he does an awful lot of stuff. But he's been, on the IT side, as you guys can imagine, incredibly busy trying to get our office ramped up and able to serve you guys with platforms like this and so forth. Lisa's our VP of Member Services, and so she's been running all of our communications and messaging and everything else we've been doing. And so they've been very, very busy people, and I want to just acknowledge them. In addition to our entire car staff, I've been sort of out there in legal bites and doing things like this, but there's a number of people, and so is Tyrone, obviously, but there's a number of people that have been super busy. In fact, our whole staff from the folks that answer the phones, because we've been seeing an enormous increase in call volume to the office, to the membership folks that are trying to get communications out, to our board services folks that are engaging with our local associations and trying to keep them on the front end of things. Our meeting and events people have been working hard to try and scramble and close down meetings that have been scheduled, get our participants refunds and take care. Anyhow, enough of that. But I want to really thank and acknowledge our staff, because they've been very busy, as I know everybody has in their own staffs. Anyhow, non-legal advice. My last note. I'm a lawyer, so I've got to give you the legal disclaimer. What I'm going to talk to you guys about today are best practices. It's intended to be informational, not legal advice. I am a lawyer. I'm not specifically your lawyer, and so I got to kick this off by making sure that everybody understands that this is not intended to be legal advice. If you need legal advice, then you need to engage an attorney within an attorney-client relationship, and that's not what we have here. So I'm seeing the room fill up, and that's great news. And so I know there's a lot of interest in all of these topics, and I'm going to play with my screen here and start sharing it. So give me just a second. Hopefully there's nothing on the back side of my desktop that I don't want to share. I'm just kidding. I took care of all of that. So here's the PowerPoint, and sorry, a little wonky, but I'm getting there. So here's the PowerPoint that I put together for this. And it's funny, today is Wednesday, the 25th. I remember I got my first call related to the COVID virus a week ago, or 2 weeks ago tomorrow, Thursday, whatever that would have been 2 weeks ago, tomorrow. And I thought, that's interesting. That was I'm surprised to get a call on this virus and its implications on real estate transactions. And since then, candidly, that has been the vast majority of my calls, for obvious reasons. It's what everybody's talking about, and I know you guys are all scrambling to hold deals together, to hold clients' sanity in check, and the whole nine yards. And so it's been a wide variety of calls that I've been getting. And so, like I mentioned earlier, I've been trying to keep some notes in terms of what those are, and that's what I'm going to go through here today. So first slide here, I just want to mention that some of the things that CAR's been doing and provide you guys with a few resources here. First of all, we've got a COVID portal on our website. If you go to coloradorealtors.com, you can see you couldn't miss it. It's basically our front splash screen. There's a link there, and we are trying to keep all of our correspondence filtered up and on there and updated. I mean, it's getting updated certainly daily, if not several times a day. And again, something Lisa's department's doing a great job of keeping going. So the COVID portal's up there. We've also got some links to NAR resources. NAR has done a very nice job of communication on this whole issue as well, for more obviously national issues. So check those resources out. One of the other things that we've been working on in the last couple of weeks, and I'm going to talk more about the essential services because that's been a big issue over the last several days, and I think is going to increase as I see some of the other counties out there in the metro area, at least, and I'm sure throughout the state, that are implementing their own sort of shelter-in-place orders. But CAR was on this with the state and with the governor's office, almost a week ago, I think, in terms of advocating that if there is a statewide shelter-in-place order, as a lot of states have done, that real estate services are considered exempt from that. And so again, I'll get back to a more detailed discussion of that in just a minute. The COVID form addendum, I think some of you probably, or many of you, saw the legal bites yesterday. Colorado Bar Association promulgated that, and it was done at our behest. We sent about a week ago a request to the Bar Association to do that, and they really acted quickly. And again, I'm going to talk about that, I think, on the next slide here. Remote notary and remote closings going to be an issue that we talk about later to some degree as well, but do know that we have been, CAR has been, and Liz Peets, our government affairs vice president, and her team have been incredibly busy trying to advocate at the state level, and also be aware of federal level stuff and local level stuff with regard to how closings are going to be taking place. I think we were very close to a remote notary bill, ironically, that would actually have been passed through our legislature this session, and still might, hopefully does. But the federal government has since stepped in, and again, I'll come back to that. We've expanded hotline availability to, it's now 8 hours a day. Normally it's 6 hours a day. So now it's from 8 a.m. to 4 p.m. straight through. We normally it doesn't start till 9. It's normally 9 to 12 and 1 to 4, but now it's 8 hours straight through. And that's just based on the volume of calls that we're getting and trying to help serve you guys. And then as some of you probably seen, I've done a couple of these COVID legal bites trying to address on a more immediate basis some of the things that are going on. So that's those are a few things that CAR has been actively working on. All right, now into some of the substance of what I want to be talking about today. So first of all, the contract addendum that was released just yesterday. This is, as I mentioned, was based on a request that CAR formally made of the Real Estate Section Counsel of the Bar Association, as well as the Bar Association, to give you guys and your clients some help in terms of creating flexibility with transactions that are either currently under contract or going under contract. And so this addendum is something that was the result of that. A lot of other states have pushed out addendums. I know a lot of you have probably seen them, have been trying to sort of incorporate language or take bits and pieces. And I think that's ultimately pretty risky. And that was part of our justification in asking the Bar Association to step up and do something. And they did in a pretty substantial and very, very quick way. And so that form is floating around out there. I know the Division of Real Estate sent it out to licensees statewide. CAR has distributed. I know a number of attorneys have distributed. So it's out there and being actively distributed. I just want to mention a couple of things about it. It's an addendum to the contract. And so, you could use it at the inception of the contract as an attachment for the original document as it's being signed by the buyer and seller in anticipation of things that may happen in this uncertain time. Or you could, if you have a contract that's currently in place and the buyer seller are having their own concerns related to the uncertainties, they could certainly add the addendum even though the contract is already in place. It needs to be signed by both the buyer and the seller. And there's really two operative sections to it. The first section obviously is important because it contemplates the possibility that clerk and recorder's offices, as an example, or title companies, or lender offices, or MLOs, or any other third-party vendors that may be associated with a transaction. I think generally they're defined as settlement service providers, appraisers. That because of administrative or governmental shutdowns or delays, they are not able to perform their services to foster the transaction that's under contract. Then it would add an automatic extension time frame based on a delay period that's defined in the addendum for the transaction. And that then just pushes all of the dates that are under paragraph 3, the dates and deadlines chart, pushes all of those out by that delay period, and then ultimately gives the parties an opportunity to set a number of days total. And that, again, would be something much further out, theoretically, 30, 45, 60 days, where if the transaction can't close because of limitations on third parties, then then the contract would terminate and the earnest money would go back to the buyer. And that's kind of the first section. The second section is focused on the parties themselves. Buyer seller can't do something. They're under quarantine, voluntary, mandatory, and for whatever reason aren't able to perform their functions in the transaction. And that would give them the ability to take advantage of a delay period. The buyer and seller section, the party section, section number 2, doesn't provide this sort of automatic termination or the ability for to set a certain number of outside dates that if the transaction doesn't take place or the party can't perform, the contract terminates. So that piece is really all about third parties, not about the principals. At some point, the principals are going to be responsible to the extent that they become quarantined or have issues outside of the normal contingencies in the contract. The buyer or seller will ultimately be responsible for performing the terms of the contract unless there's other modifications that are made that would allow them to do that. So those are the two sections. And I think you really ought to the extent that it's marketable to both parties and they want to use it, you really ought to be using that addendum on any contracts that are being formed in this uncertain period. And to the extent that you have contracts, particularly those that are at or near the front end or even middle to further end of the contract period, I would maybe encourage you to at least consider adding those addendums to those contracts, because things they're changing so rapidly that it's hard to imagine over the next day, week, 2 weeks, if you're still that far out from closing, what changes might actually take place, whether it's one of the parties becoming afflicted or quarantined, or whether it's some essential service to the transaction being shut down as a result of the mandate. So anyhow, that's the form, and I did a legal bites on it yesterday, and if you want more information, a little bit more detail on that, check that out. So some other things I want to talk about is other issues. And the form, it's a state form, and it really handles two pretty specific eventualities. There are all kinds of other things that are coming up in the course of the transaction. And that might be, the most common is a seller who says, listen, I want to just shelter in place. We have a current contract, just to set the situation up. We have a current contract. Buyer's inspection deadline is 3 days from now. And I don't want a buyer or inspector or anybody else in my house, right? But they haven't attached that addendum. And in that case, you're going to need to work through this with the parties. And, the amend extend document is very simple, and it provides fantastic flexibility for you to do that. So I think it's pretty reasonable. I mean, we can talk about, in a normal contract when a seller doesn't want to perform and the remedies that a buyer may have under the form contract, which is specific performance or damages or both. All bets are off in this environment. I think in most cases it's probably pretty reasonable and within good faith for a seller who has an inspection deadline or who has a contract with a buyer whose inspection deadline is coming up soon to basically say, listen, I'm not really supposed to be leaving my house to allow for inspections or appraisals or other services, and I don't want to, and I don't want other people in my house touching things and potentially exposing me to the virus with my family. And so that's a situation where you guys as brokers, and this is a common theme that I've been talking about, this is where you earn your money, and trying to keep deals together and forcing cooler heads to prevail, forcing buyers or trying to assist, I should say, buyers with being reasonable and practical and understanding of everybody's perspective on this thing is where you guys make your money. And that's just, there's no truer way to look at that. And so using an amend extend to say, hey, listen, okay, we're going to push the inspection objection deadline out, or we're going to push the appraisal objection deadline out, or maybe the HOA office isn't being responsive to delivering documents, CIC documents. And so we're going to push that out. Buying yourselves time within the transaction is critical at this point in time. And that's where you use this, amend extend. It's a simple document. You've had it for a long, long time. And so use it and think about ways that you can help buy the buyer and seller, or both. In most cases at this point in time, it's both, a little bit of breathing room, a chance to step back and adhere to whatever limitations they might currently have from a governmental standpoint, or just their own personal way they're receiving, and have their own independent concerns about exposure and everything else with the virus. So clauses, I mentioned, keep it simple. I always say this, that additional provision section, so to the extent that you're either writing a contract or you're writing specific clauses related to or within an amend extend to try and amend a contract to add a clause to it, you have to continue to be careful as licensees. I mention this frequently. I think that additional provisions and clause drafting is a fantastic way for you guys to get yourself into trouble because you're trying to overcomplicate things or write a clause that just gets a lot more complicated than what you as a real estate broker with a limited license to practice law ought to be doing on behalf of your clients. It's easy to screw those things up, and you're still going to have the finger pointed at you if you've done that, even though it's maybe done in a sense of urgency or in a stressful time. So now more than ever, when you're trying to amend a contract or draft an original contract that adds additional provisions or other unique clauses, now more than ever, you've got to be super diligent and try and keep it simple. That KISS principle, I think, is what they call it. Other ways to kind of handle some other things outside of that form addendum is dates and deadlines. I mean, if your buyer needs more flexibility and more time at the front end of the transaction, it may be marketable, it may be not. That depends on the seller and the property that you're making an offer on. But push those dates and deadlines out from the beginning. Push out inspection to give everybody time. Push out the paragraph 5.2, the loan review deadline. Move that out as far as possible. I think that always makes sense for a buyer, but that's not always marketable. In this particular environment with this virus going on, I think it becomes much more marketable for a buyer to be asking a seller to allow them some additional time and flexibility at the inception of the transaction if you're not going to be using the form addendum that was pushed out. So another way, easy way perfectly within your practice without having to draft clauses or come up with additional language or addendums or anything else to provide the buyer and really the seller as well with some additional time at the front end by just pushing some of those dates out. Earnest money deposits. This might be an environment where it is more marketable for a buyer to say, listen, if we're not going to be able to push these dates and deadlines out, if we're not going to use an addendum, if we're not going to buy ourselves flexibility, then we're going to request as part of our offer a much lower earnest money deposit. In other words, a buyer might be willing to forfeit $2,000 on an earnest money deposit, but if it's a $12,000 earnest money deposit, it makes them a little bit less willing to enter into a contract without some extended dates and deadlines or some flexibility that might be provided by the Bar Association's form. And so some of those items at the front end in this environment are going to be a lot more negotiable, whereas they may not be in a normal, certainly more sellers or high velocity marketplace. So those are some contract considerations that I wanted to point out. Another thing that is really emerging, I think I heard this morning that a couple, Douglas, Adams, and maybe Arapahoe County are jumping on with Denver City and County and adding to some form of shelter in place ordinance and basically mandating that, hey, if you're not an essential business, then you shouldn't be out and about doing things unless you're just going to the grocery store, getting, recreation and some of the other limitations that have been put on. So the challenge, well, first of all, what does it mean? It depends on the order, first and foremost. In other words, in Colorado, we have a state order that has directed businesses to reduce, in-person staff at offices by 50% and a variety of other things. What I would say is at the state level, currently, we have a shelter-in-place light, or very light, I might even say, compared to other states like California. There's a whole host of other states that have implemented it statewide. Basically, you're not leaving. I think Washington State did it yesterday. Everybody's staying put with very limited exceptions related to essential services. So Colorado currently is shelter-in-place light. That could change today, could change while we're on this webinar here, because that's the executive authority that is within the governor's office or governor's purview, to mandate these kind of things. So what we've ended up with in lieu of that is what I would say is much more patchwork shelter-in-place orders done municipally. And Denver's went into place at 5 p.m. yesterday evening. I'm sitting here in just outside of downtown Denver in Denver City and County, and I'm not supposed to be leaving unless I'm going to the grocery store or doctor's office or certain limited places. And so for essentials, and that certainly makes sense. Other municipalities are doing it, but the specific language within the order is super important, and you got to be careful making assumptions about what you can and can't do. I'm going to come back in subsequent slides here to talk a little bit more about some of my thoughts here. But the bottom line is the language in the specific order matters until the state steps in and makes a statewide order, if and when they do that. And then ultimately that's going to be, controlling for the entire state. And so it has had a different, a varying impact depending on where you as a realtor are at and trying to do business. What are the impacts on realtors? This kind of combines with some of my other slides here, but I'll go ahead and give you my, as an example, DMAR just had for Denver City and County's shelter-in-place order, the mayor's shelter-in-place order. DMAR did some really fantastic advocacy work through their government affairs office in getting real estate business essentially accepted out of that shelter-in-place. But that's related specifically to Denver. And wouldn't necessarily be a DMAR member who is outside of Denver City and County doing business outside of Denver City and County, to the extent that Arapahoe or Douglas or Jefferson or one of the other major counties implement their own orders but don't exempt out real estate. And so understand how those limitations work. And the other thing that I think is really important as you see these municipal, at least, shelter-in-place or county-by-county shelter-in-place orders given, is the impact on buyers and sellers. You shouldn't be just making an assumption that for you as a broker to be exempted and be able to provide services, it doesn't, in some cases, necessarily exempt your clients out. In other words, a buyer who's on their way to meet you at a showing might not qualify under the shelter-in-place exemption that has been given in certain cities and counties. And similarly, a seller who might be vacating their house to provide access for a showing right now, they're leaving their house to go and do something else might not be covered. And so I think you've got to be very, very careful as a realtor if you're trying to advise your clients, the buyers or sellers that you're representing, with regard to how any shelter-in-place orders impact them, even though you might be very clear on how it impacts you. And so do consider that as you're analyzing as you're analyzing your specific municipality or county's shelter-in-place order. And again, this will be more clear if and when the governor actually does something statewide, because then it'll just be essentially one that is impactful and it's going to apply to everybody. And so, and as I mentioned, Carr has already been advocating, and Liz's office has been advocating with the governor's office to exempt real estate. But I have some thoughts on that, and I'll get to those in a second. Those exemptions in some cases have created a little bit of tension inside and outside of the industry. I mean, I see, even associations, not just here in Colorado, but in other states through some of the national NAR listservs that I'm on. The public might disagree as to whether they want real estate brokers out running around and doing business as usual. And so you've got to be a little bit careful in how you're messaging that, I think, more than ever. And I believe that as more of this shelter-in-place stuff happens, as people feel more quarantined and more restricted in their daily lives, the public perception of how you're handling your business is that pendulum is only going to swing, I think, more aggressively as to, hey, respect your social responsibility here with regard to what you're doing. And so do be cautious as you're utilizing your exemptions or your authorization to not shelter in place in connection with your business. Use cautiously the exceptions. This is what I'm talking about. You've got to use them cautiously and respectfully. And I'm going to come back to some more thoughts right here. So open houses, is it the right time? No, it really isn't the right time to be having open houses. And I think that's commonly accepted among the industry at this point, but it really isn't the right time to be having creating opportunities for people to gather in confined spaces, such as an open house. I don't know that your sellers want that. I certainly wouldn't if I was a seller with my property listed. I don't know that the buyers want that. I don't know that any of it would be consistent with at least some of the municipal shelter-in-place orders that I've read. And so I think you've got to be having a good conversation with your client if they're trying to urge you to have an open house. That doesn't make a lot of sense right now. I'm not even sure you'd have any visitors, to be honest with you, because, you guys know from sitting open houses over the last couple of weeks, I think we've seen a real decrease in traffic and flow. Liability, responsibility, I'm going to come back to that here in a second with showings. All right, and I've got Spider-Man here. Just for clarity, that is not me. Definitely not me. I'd look a little bit better than in a Spider-Man costume than that gentleman does, but not much. I put Spider-Man up there because there's a saying in the movie that sticks with me always: with great power comes great responsibility, right? And so this concept of you guys as realtors having the power to be out showing properties or performing your essential business functions, it comes with some responsibility. And so showings, are they necessary? Well, I'll leave that to you. It certainly does fall within the category of your essential services, at least for you providing them. As I mentioned earlier, I'm not going to analyze whether your buyer, whether that same exception would apply to your buyer or seller as you're performing your professional services, but I'll let you go get some maybe legal advice on that. But if you're going to do them now more than ever, you got to make sure that these are worthwhile, that you're qualifying these people, that they're, I would say that not just financially qualified, but are we really talking about, an essential moment in time where they need to go and look at houses? Are they living out of a hotel or, God forbid, worse? Is this a moment in time where this is truly an essential service, as opposed to, hey, we know you have a rate lock, but we could put your house search on hold maybe, or we know you want to buy a house. We know you think it's a good time to buy a house, but we can wait a week or two and see where we're at with things. I'll leave that to you. I do think in most cases, if you have that business exception, then you as a professional yourself are free to be doing that. But I would be thinking very wisely about that. I've had some questions about you guys being able to ask or qualify people with regard to, hey, have you been in Italy in the last week or two or 3 weeks or whatever it's been? Or Are you at high risk? Have you come into contact with somebody with exposure? Have you had fever or other symptoms? Things like that. And then questions that's, hey, is that a fair housing or potential fair housing violation? I think absolutely not. But what you can't be doing is just asking some people. So if it's going to be part of your business practice to ask everybody, you know, are you at a higher risk? Do you feel okay? You got to do it for everybody. You can't just pick and choose who you're doing it. And I think you're going to, in that case, protect yourself from any allegations about fair housing or HIPAA violations or concerns related to that. But do be consistent in your practices in that regard. Meeting clients' properties, that's for your own protection and maybe their protection as well. You don't want to throw, a family of four in your little sedan and be driving them around all afternoon for their purposes or yours. If you're going to do showings, then I would meet them at the property, limiting physical contact with things. I don't know how that happens. And this is my concern with showings, to be honest with you. I mean, a showing is inherently a touch and feel, and they're pulling door handles and you're touching lock boxes and keys and door handles and opening cabinets, closing cabinets, dresser. I mean, people touch everything. You guys know this better than I do. Sliding doors, leaning on countertops, it is a touch and feel experience. And that is the exact opposite of what needs to be occurring at this point in time. So I don't know how you limit it, but if you're going to do it, then make sure you're thinking about that, removing shoes, carrying wipes or sanitizers. It seems a little silly to me. Here's my pitch on this for you to be thinking about. Imagine this scenario: you're a buyer's agent, and you take some buyers out who, are super pressed for time. They're living out of a hotel, whatever the situation is. You take your buyers out and you show them, and you find 6 properties on the market, 8 properties on the market. And you go and you do a normal tour. You go look at 8 properties, and imagine 4 days from now, those same buyers who you took to those 8 properties contact you and say, hey, listen, I'm going to be put on hold because guess what? I've just been diagnosed with the virus. Well, that's an interesting position for you to be in, for yourself, obviously. But I would argue, and I don't know, I'd have to think a little bit more about how it falls in the regulatory framework for the purposes of disclosure and notice, where it falls in the code of ethics or ethical framework for disclosure notice. But I can tell you, based on what I perceive as your social contract, our social contract, to be members of this society, particularly the one that we're currently residing in, is that you as a buyer's agent, I think, do have an obligation to reach out to every single one of those listing brokers and or sellers with whom you have taken your buyer into their properties and let them know that buyer contacted the virus so that they can be on heightened alert. I don't want to make that phone call if I'm you. If I'm the buyer's agent, I don't think I want to make that phone call to 8 different listing agents to let them know that I potentially exposed with my buyers, their home, to the COVID virus. And that's the challenging thing about this virus, is that it has this ability to last and stays on surfaces for much longer than what I think, and trust me, as you guys know, I'm no medical professional, but stays around for much longer than what most viruses do, and can remain airborne and all these other things. So I think that's your responsibility at this point. And I don't forget about the law, forget about your division of real estate and other issues. There's a social contract that I think need to be particularly now adhering to. And similarly, if you're one of the sellers, you're a listing agent, and you've had 10 buyers come through your house and look at properties over the course of the last week, and then your sellers find out that 1 or more family members within that household have the virus, I think you as a listing agent have some responsibility to be reaching out to all of those showings over the last week, 2 weeks, 5 days. I don't know what the time frame is. To let them know, hey, you were in the house, sellers had the virus or have been diagnosed with the virus, just be aware. And that's the social contract. I'm not even going to get into the potential for liability, and does it fall within your standard of care, and are you going to see lawsuits or errors and omissions claim if you bring a buyer into a seller's house? You notify that seller that your buyer had been diagnosed with COVID. Are they going to be asking you for the deep cleaning and their hotel nights out while they allow the period to move past? Are they going to be going and suing you after the fact? I don't know. We are in uncharted times, but as you guys are working through this stuff, you have to be thinking about those issues in the scope of what is essential and what's not essential. So I'll get off my soapbox here on that particular issue, but Couple of other things I want to just mention. You got a contract and you've got your buyer who's under contract currently. And they need to perform inspections because that's what the contract says. They got to do it by such and such date, or they got to get an appraisal, or whatever. These third-party vendors or third-party settlement service providers need to access the property. This is creating an awful lot of tension in the marketplace. Sellers saying, I don't want to let them in. Buyers not being willing to go and meet those dates and deadlines. This goes back to what I mentioned earlier. This is a perfect time for you guys to step up and utilize amend extends, utilize your sales and brokerage skills to get things signed and to get your clients to agree to cooperate with each other if they want to hold the deal together and if they're truly interested in acting and performing in good faith under the good faith clause. And so I have had a lot of issues with regard to those tensions. And I think to some degree, all bets are off because I do think it's probably reasonable and within good faith for a seller to say, I don't want to allow access right now. And a buyer or a buyer to say, I don't want to perform an inspection or appraisal because I don't want to show up. I don't want to be on site. Not that they would necessarily be there for appraisal, but for other due diligence matters. So think about that. Broker. This is where you guys earn your money, and I'll come back to that at the end. The last thing I'm going to mention on this topic is I've heard some rumblings in this state. I've heard a lot of rumblings from other states on some of the national listserv stuff that I'm participating in regarding waivers or hold harmless documents. And this would be a situation where a large brokerage firm might be looking to have, or any brokerage firm, any broker might be looking to have their client, their buyer, sign a hold harmless or waiver. Hey, if I'm going to show you a property, and you happen to transmit the disease or contract the disease, you're not going to hold me liable for that. Or the seller who says, I absolutely want to do showings in this market, I don't care. And you as a listing agent saying, all right, seller, if we have showings and a buyer comes into your property that I've provided access to through the MLS, you're gonna hold me harmless for if they leave contamination or the virus in your property, you get it, you have damages, you're gonna hold me harmless. It's these liability sort of shifting clauses. And so I'm gonna tell you right now, you will not be seeing one from the Division of Real Estate because, well, you just won't. I mean, they're not going to create clauses. Their primary mission is to protect consumers, and these documents would do nothing but shift liability from a broker to a consumer. And so you're not going to see one there. You're not going to see one from Colorado Association of Realtors or your local realtor association because we can't practice law. And any of these liability shifting documents, waivers, indemnifications, release of liability, any of these things are contract documents that create legal obligations or waive legal obligations. And so we simply can't do it. I couldn't draft one for you if I wanted to because we don't have that attorney-client relationship. So if you're looking for this stuff, you can go and get your own attorney to potentially put something together, draft something for you, because that's the only place you're going to get those kinds of documents at this point in time. And I don't even see in the future that either the Division of Real Estate or CAR is going to have any ability or willingness to promulgate those kinds of waivers or liability shifting provisions. And I would say that if you're looking for those things, you got to be really wondering if you're working on the right deal or working with the right clients. So remote closings and remote notary is has been another big issue here. I'm running late on time, so I'm going to pick it up a little bit so I can make sure I save plenty of time for questions on the back end. I'm just going to say here that there is, we thought we were going to get some progress this session, and we still might on statewide remote notary. I really hope we do. CAR has been working very hard on this bill, and if the legislature gets back in session and it can get passed, then we'll have it at least in the state of Colorado at some point in the future. At the federal level, the Congress is looking at doing a nationwide remote notary, and so that might be pretty effective and be pretty helpful in allowing notaries to use platforms like this to verify and notarize documents remotely. Certainly an important possibility, and so stay tuned on that. You still can be doing remote closings or mail-out closings. Those can take place currently in the state. You would need to have some notarization, and that's going to have to be in person. And as you guys who've all been through notarizations with clients, there's a lot of touch and feel and handing of documents, and driver's licenses, signing, pens moving around, and everything else. So if you're going to do it, you can have private in-person notary potentially come and do that. But again, it's a balancing test. What are the risks and what are the rewards? Government offices closing, and what happens with regard to title companies now. So clerk and recorder's office shuts down for a period of time. Title company might be able to close that transaction in escrow so everybody gets their stuff done. But let's say you've got extended coverage or O&E within the contract. And one of the most important things that covers is that gap period between the time of closing and the time of recording. Well, the more time that transpires between the closing and the recording, because a clerk and recorder's office is closed or not able to accept recordings, the higher risk there is that something actually gets, that a problem gets created within that gap period. And so because of that, we are seeing some title or insurance underwriters that are limiting their gap period exposure if they're offering that insurance. And so you as a broker, the takeaway here is to understand with the title insurance company, if they're going to issue a O&E policy, and they're going to delete the standard exceptions, including the gap coverage, what exactly does that mean, and how does that impact your buyer if closings ultimately get delayed? And then there's a whole bunch of stuff with regard to deal termination. Paragraph 5.2, this is job loss, financial insecurity, financial markets, ability to pay. A lot of brokers and their clients think that paragraph 5.2, which is the new loan review, is the bank's approval of that buyer to purchase. Well, it is that, but it's also the buyer's ability to consider all the aspects of that loan that they're getting, including the mortgage payment, interest rates, and their ability to perform all falls into that. And I think if in good faith they're making determinations that based on job loss or financial insecurity or potential job loss, I think that paragraph 5.2 is sufficiently broad. I don't necessarily love it, and some of you have heard me talk before. I think sometimes I think it's too broad. It's too punitive on sellers. But in this environment, again, we're living in a very unique time, and how people respond to that is going to be unique as well. However they're using that, your buyers have to understand if they are utilizing it, it's got to be done in good faith, pursuant to paragraph 29. In other words, it's not just hey, I'm done, get me out of the deal, or maybe I found another property, or I found a cheaper property because we've seen some price dip and whatever it might be. That's not good faith. And so keep all of that in mind. I'm getting a lot of sellers refusing to release earnest money. And I think in most cases, the sellers are just feeling jilted. They've lost a deal. It was appropriately terminated within the deadlines in good faith, and they just don't want to sign an earnest money release. Well, the contract in paragraph 4.3.2 says they're supposed to do that within 3 days, but it doesn't really say what happens if they don't. And so now you're into mediation and potentially litigation and small claims or other court. Not a great time to be dealing with any of that. But if you're a listing broker and you're working with a seller, you do need to make sure that assuming that everything else has been done properly, you need to make sure the seller is aware of how those dates and deadlines work and what the contract at least says with regard to their obligations to also act in good faith in signing an earnest money release and releasing that earnest money back to the buyer. I've talked several times about the good faith clause. I mean, that's just an overriding expectation that both parties are acting in good faith in the contract. And once again, now more than ever, that is an incredibly important concept for your buyers and your sellers, and you as a broker to be reminding them what those expectations are. So I mentioned job loss and financial insecurity. Those are all what your clients, particularly on the buy side, are going to be doing right now, and potentially on your seller side as well. Potentially on your seller side, they got their house on the market or under contract because they've made a financial commitment to purchase another house. They were going to upgrade, and then everything changed on them. Now they don't want to sell. Well, they don't have the contingencies and the ability to terminate that a buyer would based on their change in circumstances. But, things are changing for buyers and sellers in this market. And that's why, communication is paramount and key. And you guys are, as brokers, right in the middle of that definition. So make sure you're doing it. And then inspection versus appraisal versus loan versus other. I get a lot of calls from people that say, maybe a broker doesn't realize how broad or that the loan termination or the new loan review deadline is as broad as it is. And so they say, well, my buyer got fired and so we think we just want to terminate based on inspection. Well, no, inspection is terminating based on the condition of the property, not the financial condition of the buyer, but you can take advantage of new loan review, assuming that deadline still exists. the contract just beginning this year now has some language in it that says the appraisal is specifically not part of the loan. The appraisal is its own deadline. And so make sure and this is not just in this market, but it's coming up more often in this current environment. Make sure that your buyers are exerting contingencies that are A, in good faith, but B, appropriate with what they're intending to object to or terminate based on. Some other random thoughts that I'm going to hit on real quickly. For landlords, the apartment association just released some guidance for them. Working with tenants in this environment, everybody is hurting. Coming up with payment plans, trying to structure something with your tenant, communication with your tenant, waiving late fees for some reasonable period of time. I think in most cases, evictions are just not going to be processed. The state and the Colorado Supreme Court has really left up to the local county courts to make decisions about processing evictions at this point, but I'm not familiar with anybody that's doing it right now. And so, you don't have, as a landlord or as a property investor, the normal hammer that you would in a normal environment. You just don't have that leverage of posting your notice and moving through with the eviction process. So it's better to communicate, work with your tenants, understand that, to some degree I don't want to sound cheesy, but we are all in this together, and everybody's doing what they can to keep their head above water. I know you guys are, but your tenants are as well. So be thinking about that. Limiting property access was another guidance at the apartment association. And that is, for maintenance or management type issues, only kind of life, health, safety, or super pressing or emergency kind of scenarios would you want to be sending in vendors or contractors or yourself or anything else. So I think now is a reasonable time to be, again, within the purview of communication and other state law, trying to limit some of that. Foreclosures, there's all kinds of forbearance, mortgage forbearance incentives out there through the federal government. I think the state's trying to do what it can. That's and I get it. There's a lot of landlords who are in this. They rely on their monthly rental check to service their monthly mortgage payment, and I acknowledge that, and so does the federal and the state governments. And I think as part of that, I think you're going to have. Well, I'm certain that you're going to have some breathing room, assuming that you're working with your tenants in that case, and in good faith, not able to make mortgage payments. So I don't have time in this to get into the federal stuff that's gone on, and I know there was just a package, a pretty aggressive package passed by Congress, I think, today. So check it out. There's tons of resources out there for you. I mean, everybody has got some COVID resources, I think, on their website, whether it's medical stuff through CDC or World Health Organization, whether it's Consumer Financial Protection Bureau, the federal agencies that do this stuff, Division of Banking in the state, Division of Real Estate. Everybody's got some resources. And if anything, I think most of you guys have time right now. So if you're having questions, a little bit of Googling, it's a fantastic service. And thinking about the logical place where you want to receive those resources, they're available out there. Tiger King, other random thought. My kids and my wife got me watching this 2 nights ago, and it was funny because I was looking, I saw a news headline, and it's on Netflix. This is insanity. It's the headline this morning, and I can agree after watching, I think, 4 or 5 episodes of it. It is the only show that is crazier than the world we are living in right now. It's on Netflix. Check it out. And you don't come here because I'm Siskel and Ebert. The last thing I'm going to say is chins up. Keep your chins up, guys. This is tough. The one thing, unless you're like, a stockholder in Zoom or have a commercial cleaning company or, very limited area, everybody is dealing with the exact same thing right now. Everybody. And so I know it's not easy, but if ever going forward, and I've been saying this in my legal bites, if ever there's an opportunity for you to expand on and learn how to articulate your value proposition as a realtor, because I've been talking about it in the context of your clients, challenging you on commissions and you're overpaid and all this other stuff. This is a perfect opportunity for you to be adding to your value proposition. You are a broker. The core definition of broker is you're working between 2 parties to try and make things happen. And I know it's hard and whatever. You guys we're going to get there. In the meantime, it's, chins up and positive attitude, think creatively and reflect on that value proposition. But in this scenario, you're going to have a sales pitch that I think is going to go out for a long, long time in terms of what you guys are doing in the marketplace, how you're holding deals together, how you're thinking creatively about transactions and getting things done, and how you're servicing your clients. So now more than ever, there you have it. All right, I'm going to go to some questions here. A couple of other resources. Colorado Realtors, the legal hotline. You can subscribe to Legal Bites on YouTube. I'm going to stop sharing my screen, and I think I'm back on here. Q&A. I got a bunch of them. And guys, it's 11:20. I'm going to go. You guys can jump off anytime you want. That's the beauty. You won't even offend me when you walk out of the room. But I'll try and get through as many of these questions as I can, assuming that I'm comfortable answering all of them, and do what I can. So first question I've got here is, let's see, what is the wording should be written on the MLS for showings of vacant homes? I guess what you're asking there is in the broker remarks or something, the expectations that the seller has on a vacant home, which presumably provides less risk. Although, if you have 10 showings in a day of a vacant home and figure average 3 or 4 people on a showing, you've now had 40, 50 people come through a house. Again, touch, feel, touching things, grabbing things, opening. I mean, I don't know. I don't know if that's, I'll leave that to you guys. Nonetheless, wording, I think I'd say, first of all, maybe ask your seller for the wording. If your seller wants to have showings of their listing, you might say to them, what instructions do you want me to provide through the broker remarks with regard to the property? I guess you could leave out hand sanitizers everywhere and wipes and everything else, although those are kind of hard to find right now. I don't know that there's proper wording in the broker remarks for that, but if I didn't answer that or you want to talk more specifically, then just call the hotline. I'll be covering it from 12 to 1 today. But that's a good question if you want something more on the hotline. I'm not sure there is a proper answer exactly, though. Number 2, the shelter-in-place verbiage in number 2 of the addendum seems automatically extend all contracts in countries under shelter-in-place, but many of those buyers and sellers can still move and want to. I think shelter-in-place should be removed. It doesn't automatically extend for that reason. I understand extending for quarantine scenarios. Well, I guess I would agree, and if I agree, then I would say buyer and seller, if they want to move forward, can remove the addendum. In other words, don't use the addendum if you're a buyer and seller and you don't have limitations on your movement, and you still want to close and everybody wants to proceed with the transaction and are able to, don't use the addendum. Or if you've used the addendum and the buyer and seller decide that they want to remove it, they could always do an amend extend to remove the addendum at that point in time. But your question is assuming that a buyer and a seller both want to participate in moving forward with closing. Well, nothing would preclude them from doing that unless they had an addendum in place that they wanted to do that. And again, I think you're making an assumption that this is a statewide form. And so anytime you're doing statewide forms, there's limitations on that in terms of trying to account for various situations, including the fact that because we've got a patchwork framework of shelter-in-place orders at this point, we don't know from county to county whether real estate's accepted or not accepted. And I can't make that assumption. So anyhow, I don't know if that answers your question, but that's my thoughts on that. And again, you're free to remove it. Will Carr email us your PowerPoint? Sure, I don't see why not. You need something to help you fall asleep at night there, Steve. Hope you're doing well, buddy. Can a buyer state force majeure on a termination? That is a very specific legal question. And so, kind of the concept of that addendum is a bit of force majeure, particularly number 1 on that new Bar Association addendum is that those are concepts of force majeure. Some third party as a result of COVID can't perform, and therefore the buyer and seller can't perform. I don't know is the answer. There is not a force majeure clause in the state form contract to buy and sell. They probably will never be. Is this force majeure? It's something I've been thinking about a lot because as we were getting ready to try and cancel contracts with some of our vendors for like our spring summit and other hotels and resorts up in the mountains and other things, a lot of people are talking about force majeure. The problem you've got is this. that is a legal opinion if you're telling your client, your buyer or seller, that they can terminate based on force majeure. If they don't have the benefit of an addendum or some other contingency that is appropriate to utilize in good faith, and your client wants to terminate a contract, your advice to them is, in writing, please seek legal counsel and determine whether, or get a legal opinion as to whether or not it's force majeure. At this point, I just don't know. This is new and emerging, and ask me in a few years, and maybe we'll have some case law or some other formal judicial opinion from some court in Colorado regarding this, and I'll tell you at that time. On the new COVID form, do you check both boxes, one or the other? Good question. Whatever the parties want, you can check one, both, whatever seems to make the sense and the parties want to account for. They both are available, though. So very good question. How can I protect the buyer who wants the ability to terminate and get his or her earnest money back if lending shuts down for any period of time or some other provider, title company can't perform? Well, that is the gist of that addendum. Now, if you have a contract in place and the seller, so the whole purpose of particularly Section 1 of that Bar Association addendum addresses your concern. And so if you have a contract and that's a concern, you can always, your buyer or you as the buyer's agent can always have your buyer sign that and offer it to be amended into the contract and added to your current contract. If the seller says no, I think that's where, we might be back in that sort of force majeure question, because the contract doesn't specifically contemplate for it. But again, now, so let's say the buyer doesn't perform and they don't have a clause or other out. Now you've got an earnest money dispute. And I don't know, we're going to be asking judges, probably county court judges all over the place in the coming months and potentially years to decide, was it reasonable, or were there such outside forces on the transaction at the time of this virus that it was reasonable that the buyer didn't perform even though they were contractually obligated to. And so I don't know, to be honest with you, if a seller's not willing to cooperate, hard to answer that question. We'll see. We'll have some answers to that, but it's not going to be anytime soon. Again, you take advantage of your brokerage and sales skills to try and get the parties on the same page. People need to be working with each other at this point in time, and that includes obviously buyers and sellers. My buyers own a business that is considered non-essential and needed to close their business since Governor ordered 50% of COVID. We're under contract and we're originally scheduled to close on 3/23. However, lender cannot continue lending since business income is effectively reduced by half. Trying to get an amend extend to 4/30 with seller. If they don't accept amend, does buyer get earnest money back? Same gist of the question I just tried to answer. Work on that amend extend. I mean, my argument, first of all, I would hope that on some level, unless there's completely counter outside forces, that a seller is going to be willing to work with a buyer at this point in time. Seller doesn't want to go put their house back on the market right now. They don't know what landscape we're going to be living in 3 days, let alone 3 months. And so if I'm a broker, I'm using that to try and help a seller or the other party to a transaction, trying to help them advocate for your client and explain to them, that you may want to play hardball, but it's not exactly the right time to play hardball because there's so much uncertainty. Do they get the earnest money back? I don't know. It goes back to what I'm saying. If the seller's not going to sign an earnest money release and the buyer's not going to sign an earnest money release, then there's paragraph 23 and 24 control. They're going to have to request mediation, and they're going to have to get with the earnest money holder and figure out what election the earnest money holder is going to take. But if they can't mediate it and nobody's going to sign an earnest money release or settle it in some other way, then they're going to be asking that question of a judge at some point in time in the future. And if a judge is going to see behavior that is unreasonable by either or both of the parties, I don't know how they're going to react to that. So we'll see. Jefferson County shelter-in-place order doesn't mention one way or the other if real estate is essential. What do you think? I know real estate is essential. I know it is. We all know it is. It's the driver of our economy. But if the order doesn't mention it, then I don't think it's probably excluded. I haven't seen the Jefferson County order. I just don't know at this point what applies because I haven't read it. I will say this. Generally speaking, these orders are drafted as such that they specifically say shelter in place with these exceptions. And if you don't fall under one of those exceptions as being essential, then then I would assume that you don't have any exceptions to what you're doing. And so, essential, I know you guys are all essential to me, every one of you. It's, I know what you're doing, but whether or not a mayor or governor thinks that is a little different. Is it okay to advise only inspector, not agent or buyers at inspections? Of course, with full disclosure that it would only be the inspector. Piper, good question as always. And yes, I think so. I mean, ultimately, that's going to be up to the buyer. If a buyer doesn't feel comfortable with that, and that's what the seller is requesting or demanding, again, I think at this point in time, our standards for what's reasonable in good faith have shifted dramatically in terms of access to a property. So if a seller is saying, hey, I'm happy to allow the inspector in, I don't need 7 other people accompanying them, then at that point, it's kind of in the buyer's court. Is the buyer willing to proceed? Do they want to do an amend extend to push it out? Do they want to just trust the inspector to go in and do their business and provide them with a report? That's a brokerage and a negotiation thing. But I think it's probably reasonable for a seller to mandate limited people on the property, and including no people on the property at all. But we'll see. So let's see. If I want to withdraw the listing from the MLS for a period of time, but want to keep the listing contract active with the seller, can I do that with an amend? Will that clause cause problems after May 8th if it is a kind of pocket listing? Boy, you've really tied in some. I thought I was going to be spending this time of my year talking about coming soon and the new clear cooperation policy, and I wish I was. I actually wish I was outside picking daisies in the springtime and skipping around in my front yard. But I guess things change. But you've tied 2 things together here. So remember this. All you're doing is all I would say you need from your seller if you're going to withdraw the listing is an email from your seller and something in writing instructing you to take the listing off the MLS, withdraw it on the MLS. Withdrawing it on the MLS doesn't have an impact on your exclusive right to sell agreement with your seller. And so I don't think there's any need to amend that. The way I might encourage you to try and amend it to the extent that your seller is going to be responsive and cooperative with this would be to say, okay, we're going to withdraw it for a period of 3 weeks. I'd like to say that in an amend extent, and then I'd like to also add 3 weeks because of that to the back end of the expiration of my listing agreement. I think that's a reasonable request. And if you've got that kind of relationship with your seller, then you could certainly buy yourself time with that. But if you're just withdrawing from the MLS, that needs to be done with a written instruction, because in the exclusive right agreement, they have said to you, or you have promised to them that you'll be marketing it actively on the MLS, and you're no longer be doing that at their instruction. And honestly, I think an email from them, some writing from them is probably fine to do that. If you want to do an amend extend, great. But that doesn't affect the overall termination date or the timing or expiration or end of your listing agreement unless you guys specifically do that. So you would want to do an amend if you do want to try and recapture that time at the end. Again, I think that's an a very fair request. And if your seller will cooperate, that'd be great. Oh, the pocket listing thing. Gosh, I don't know. I'd have to think about how that would have an impact in terms of, the MLS rule, unless they delay implementation or something, I think it is going to be the MLS rule. And I don't know if it's May 8th. I think the NAR mandate was that was in place in all realtor-owned MLSs across the country by May 1st. And so I'm not sure where that May 8th deadline comes from, but I'm just reading your question. So I think unless the MLSs or NAR gives the MLSs exemptions between now and May 1st to implement this, which might happen, things are changing all the time, then I think you're still, at any point after May 1st, assuming that's the implementation date, going to have to comply with your MLS rules, which are going to say essentially, if you're doing public marketing or within 1 business day of any public marketing of a property, then you've got to have it entered into the MLS. So hopefully that helps give you some direction. My buddy, Amy Ashenbrenner, is this presentation going to be available for local associations put out to members? Thank you for the easy question. Yes, it is. We're going to have, this is all being recorded, which I'm horrified. But it's all being recorded, and Carr will get this uploaded. Again, Lisa and her department will get this uploaded to YouTube, or so I don't know. You'll see it. It'll be out there, available. Don't hold me to any of this stuff, though, because it's, I'm kidding. Let's see. Is it possible to state in additional provisions on listing/buyer agreement a statement regarding the hold harmless concept for risk of COVID-19? Or is that an attorney? So fair question. Could an attorney prepare a clause for you that would do that? Potentially, yes. You should not be writing any liability shifting clauses or provisions yourself. So I would definitely, yes, absolutely talk to legal counsel. I would say yes, that in a listing agreement, if there was a properly drafted and implemented hold harmless or any other language in the state farm listing contract, exclusive right contract with a buyer or a seller, then that could go in there and it would change the relationship between the parties. I don't, as a policy matter, I'm not sure I like it. I think as a marketing or sales matter, if I'm a client with the exception of very limited situations, am I going to allow you to, or am I going to be willing to accept a contract where I'm basically agreeing to indemnify you or waiving your liability or anything like that? But talk to your attorney if you're trying to do something like that. In the meantime, let's see, where do we find legal verbiage for the COVID extent, amend, extend, and addendum docs? It's a form itself, so it's not a clause. It's not just legal verbiage. It's actually the form. You can find it on our website if you go to the COVID resources page. Like I said, the Division of Real Estate sent it out yesterday. We distributed pretty broadly to the form software providers in the state, including, well, I'm not going to get into names, but most of the form software providers have the agreement, and they've, I think, have uploaded it on the back end. So it's the COVID-19 addendum to the contract to buy and sell. So don't use the language, use the form. Don't pull language out of it or verbiage out of it and use that. Use the actual addendum form itself. That's the safest and best, and that's why it was created. But at a minimum, you can find it on our CAR website. Again, if you go to that main homepage, there's COVID resources. It literally smacks you in the face right in the middle of the page. Click on that, and I know that was uploaded. There's a link to a writable form that you can find there. That was done yesterday. Never mind, Jeffco's order addresses real estate as essential, so apparently Jeffco does. I haven't read it, so I don't know. Scott, on vacant land contracts currently going, can you just do an amend extend to extend the closing date just because the buyer is nervous about what construction will be like in the next couple of months, or qualifying for a construction loan might change? Very good question. I mean, absolutely. You can do an amend extend on a vacant land contract for any of those reasons. The challenge you're going to have is it's going to have to be, while the buyer certainly may want that, it's going to have to do an amend extend. It's got to be mutually executed. So you're going to have a seller accept it and acknowledge it and agree to it. So, I'll leave that to you to negotiate. But again, in this marketplace, I think for a buyer, that is a reasonable request. And I would hope that a seller would try and accommodate them. And again, my argument as a buyer's agent would be, we want a standard contract. We're going to continue to perform and act in good faith, but we need some flexibility. We need some breathing room. And the alternative, I guess, would be to, seller's going to put the land back on the market. Do you have your Spider-Man pants on hiding under the table? Okay. Well, you know what? I'll show you. So just to liven things up, I actually do have my jammies on. So for those of you who saw my legal bites from yesterday, I'm a human mullet. I've got I'm business up top and party, maybe not party, maybe sleepy on the bottom. So I'm not sure if that's a mullet, but anyhow, you caught me. There you go. Veronica, my friend in Boulder, will you be distributing the link for this session? Yes, we will do that today. Let's see. You are basically saying do not conduct business if we have any. I hope that's not the message that I'm saying. I mean, I'm encouraging you to act responsibly and to consider what you're doing and the impact, and also the liability. And so, am I encouraging you not to conduct any business? No, I'm encouraging you to be mindful of the world that we're living in, and to the extent that that you're not, or we as an industry aren't respectful of what I think most everybody in the world right now considers to be part of the social contract that is holding us all together. If as an industry we're not being respectful and mindful of that, then it's not going to reflect well for anybody. And so that doesn't mean, hey, listen, we've got a closing here, in a week, we can't perform business. You're going to have to broker and figure out ways to make that happen. Work with your title company, work with any other vendors, parties, whatever you need to do. But to the extent that, hey, we'd love to find a house at some point, buyer, or a seller who says, yeah, I don't know if I really want to do showings. I'm not really sure. This is where you're just being responsible. So I hope that's not what the takeaway is not conduct business in any way, even if you have any. You got to use your head. That's what I'm saying. Let's see. It seems like low earnest money puts the seller at risk if you get past all the deadlines. They move out and pay for a lease, and then the buyer just doesn't show for closing. The seller has a lot of risk. I don't see why that circumstances should change earnest money from the seller. I don't know that it does change earnest money from the seller's perspective, Elaine. In other words, I'm saying that the market has shifted. If I had, a year ago, or let's say 3 years ago, when we had just super high velocity, it was clearly a seller's market. It has been clearly a seller's market. The power dynamics, I think, in real estate transactions right now are different. I think most of you would agree with that. And so to the extent that you're a buyer's agent working with a buyer and you're trying to figure out ways to accommodate your buyer and their best interest in an offer or in a change to a transaction, I think that's not, is it going to be acceptable to every seller? Of course not. Is it going to be acceptable to some sellers? Potentially. And I think it's another, arrow in your quiver if you're a buyer's agent to be thinking about. Whether it's acceptable or marketable to a seller, I have no idea. It might be, and certainly would be more now than it was, very recently. Thank you so much, Scott and team. We're lucky to have you. You're sweet, Kate. As always, thanks for your kind comment there. With respect to waivers to other brokers who want to show your listing, will we need to get a legal signature or simple acknowledgement via email? I don't know. I'm not sure so you're saying if you're a seller's agent or listing agent, you're going to be asking another agent, a buyer's agent, and or their buyers to sign a waiver. I'm going to send you back to get legal advice. If you've had somebody draft the proper waiver for you, in other words, an attorney, then I would figure out from them or get legal advice from them with regard to how it needs to be executed, who needs to execute it, et cetera. So I don't know. I'm not sure. I can't tell you if, a legal signature or simple acknowledgement via email. Emails and texts are generally considered writings and probably enforceable, but I'm not sure the document you're referring to, so it's hard for me to speculate there. Should the agents be also preparing an amend extend to incorporate the COVID addendum in the contract? Yes, I think absolutely. If you've got a contract that is, unless you're, days away from closing, I would encourage the buyers and sellers to be considering implementing that COVID addendum, again, the Bar Association's addendum, implementing that through an amend extend into the contract as appropriate. So it's certainly, if you're at the front end of a transaction, listen, if you had told me, 2 weeks ago that I would be talking about shelter-in-place orders, I would have laughed at you. And here we are. And so I don't know what we're going to be talking about 2 weeks from now. And therefore, if there's more than just a couple of days between the transaction, where the transaction currently is, and the closing date, I would encourage you to be really considering that addendum. Would it make sense for Carr to lobby Governor Polis to enact a balanced stay-at-home policy similar to the revised city and county? So Carr is. On our COVID resource web page, you can see the letter that was sent out by Robert Walkowitz, our chair-elect, Janine Johnson, our current chair, and Tyrone Adams, my boss. I love doing that to him. They sent it to the governor's office on Saturday, I think, or Sunday of last week. So we are asking for that. At this point, we have as balanced of approach as on a statewide level as any state, and because they haven't been. I'm going to take this point a little bit further, because the governor wanted to see if people could behave themselves, I think, and so that was the policy before Sunday, and then on Saturday. I think, I myself drove by. I didn't get out, but I drove by Wash Park. I had never seen it so crowded. Just, volleyball. It looked like twice as many people as the busiest day of any summer day that I've ever seen it. And I think it was things like that, and some videos on the internet, up by Loveland Ski Area and up, in Berthoud Pass, and a lot of backcountry stuff with miles of cars backed up with traffic. Basically, they said, hey, we've got to crank down a little bit more. And so they issued the more limited version. I think if the behavior doesn't end, if we continue to have people disregarding the social distancing expectations and the responsible behavior, then yeah, you're going to see a statewide order, and we're going to work to have real estate defined as essential, but there's no guarantees. NAR has been keeping a list of states and municipalities that have done it, and it's less than half, I think, candidly, at least the last time I looked, of states or municipalities that have actually exempted out real estate from their orders. So anybody's guess, but it goes back to the whole idea of acting responsibly. God, you guys are full of questions today. I'm going to keep going. So let's see. I'm a photographer that shoots real estate and have the new protocol of not meeting people when we're shooting the property. So we can meet the broker, but then the broker unlocks the property and then we shoot without touching anything in the home. We are asking owners to leave an hour prior to shooting the home. We bring hand sanitizer, wash, and disinfectant. Do you think this is good protocol? Well, sure. I mean, I think any sanitizer is good protocol. I feel like when I'm outside, I want to just spray something at everybody, but that's not socially responsible either. I emailed a legal person for photography on the waiver of liability of the home. Does this sound like a good way to go about it, since brokers are going to depend on photos? I mean, same issue. Assuming that you determine that you are exempt as an essential individual or business under whatever order in whatever jurisdiction you're living in, if you make that determination, then it's a matter of carrying on whatever you're doing in as responsible a fashion as possible, and taking all precautions for you and for your vendor or for your clients. I mean, and so, I mean, listen, if you infect a home or you spread it among homes or you get infected because of your exposure, I don't know where at this point, this is the new frontier from a legal standpoint. I don't know where liability begins and ends, and what's covered or not covered under any insurance policies that you might have. But I do know this, lawyers, and I'll say this: I've never sued anybody, or never been sued by anybody, so I'm not a litigator. But I do know that those evil lawyers, they take what we call a shotgun approach to litigation, and that is when you sue somebody, you sue everybody. And so, keep that in mind as you're considering how you are doing your business. And can a tenant terminate their lease citing act of God if that provision is in the lease? Ask a lawyer. I'm not your lawyer. I just don't know. Again, it goes back to it's the same concept of force majeure that I talked about earlier. I just don't know, and you don't either. If they're asking you, they're asking the wrong person. And so I can say what I want, and if you want to turn around and parrot it to them, you're just going to be providing legal advice. So, and we are, again, I'll reiterate, we're in such a unique time that that a lot of people are going to be asking a judge the answer to that question on a lot of different contracts in the next, 6 months to 6 years, probably. Does a seller have the right not to sign an addendum extending deadlines due to COVID, or is that acting in bad faith? That's an interesting question. No, I would say a seller, generally speaking, that's a really good question. What I like to say, generally speaking, is that a party has no, buyer or seller doesn't have any obligations whatsoever to amend, extend, to do really anything in the contract. So my initial answer would be no, a seller or buyer would not have to accept the new addendum that came out to amend and extend the contract and incorporate that addendum. That's my first blush answer, and that's the answer I guess I'm used to giving. How good faith interplays with what we are currently experiencing is so unique in our industry, in our society, and so I think it's a really hard. It's hard to assume how this will be interpreted going forward, because let's say a seller, in your example, doesn't sign one, buyer ends up, not performing. You've got an earnest money dispute. Ultimately, that's going to be up to the judge in an earnest money dispute, or the parties to settle through mediation. And it's a different thought process, I think, right now. So hard to answer, and kind of sounds like I'm starting to repeat myself in some ways. But how would you protect a seller under contract in the event their circumstances change and they need to stay in their home, not sell? Well, okay, interesting question. Now we're back to the other side of the equation. So the seller says, I don't want to allow the buyer to perform. I don't want to provide access. I don't even want to sell my home at this point because my financing have changed. The contract to buy and sell, as all of you guys know, probably better than I do, or certainly as well as I do, it's set up with a whole bunch of contingencies for a buyer to perform their due diligence and terminate or object and seek modifications to the contract, but also terminate. It does not provide a whole bunch of opportunities for a seller to terminate. And so in the situation where a seller says, and as any of you have heard me talk about this before, I think a seller refusing to perform is one of the most difficult situations of any contract to buy and sell. It's the most difficult scenario that you might face as a broker, because what's the buyer's remedy for seller's failure to perform? It's specific performance or damages or both, okay? And so a buyer certainly would be eligible if a seller said, I'm not going to perform to receive, costs for inspection and loan application and all of their reasonable costs in the transaction as damages. They could be eligible to receive specific performance, but remember, specific performance is injunctive relief. And if a buyer is looking to get specific performance, it's not necessarily something that's going to happen in a matter of weeks or even months if a seller is really contesting that. And so then you throw into that. So I guess what I've told a lot of people in the past is that I don't believe that specific performance, at least for a primary home, it's a terribly practical remedy for a lot of buyers, right? Trying to enforce specific performance against a seller is a bit impractical in my opinion, but it is one of the remedies under paragraph 21 of the contract. So they need to talk to an attorney if that's what they want to pursue. But the curveball then just comes back in with what feel like I've been repeating myself with, is that we're in uncharted waters. I mean, if a judge could imply the concept of force majeure or act of God or whatever, any of these other clauses into the contract for the benefit of the seller, then sure, months or a year from now, when they're litigating out a specific performance action based on a seller not performing under COVID, you might find a judge that determines it to be force majeure. Well, in that case, your buyer has just spent oogles of money on lawyers trying to pursue specific performance, and your seller is going to be successful. So, hard to say, very unique time. But let's see. What if one of the parties is unwilling to sign a new addendum? I answered that previously. What's a reasonable time frame to extend at this point? I don't know. I wish somebody would tell me. If somebody would tell me what a reasonable time frame is at this point, I would love you forever. Not that I don't already. I just don't know. I mean, I don't know. I think you can always extend and then agree to re-extend, or you could have a clause that would naturally extend if certain circumstances are existing. Again, be careful if you're writing those kinds of clauses. I think it makes sense to take little bites out. Breathing room, breathing room, breathing room, breathing room. And so I am really hopeful that that my answer to that, I can look back and say, well, I could have easily said reasonable extend would be 15 days because we'll be back to business as usual at that time. I don't know. I just don't know. I hate to punt on questions, but I'm punting. Boulder County Public Health says stay-at-home order has been amended. The following legal title, relationship appraisals and transactions. So it sounds like, and if I trust anybody, it's our CEO of BARA up there, Veronica, who is awesome, and she says that professional services include, among other things, real estate appraisals and transactions. So it sounds like that's the case. Again, I haven't reviewed it, but again, that means appraisers and real estate professionals are out running around. But can your buyers and sellers be? I don't know. I'd have to read it in context and be careful about my answer there. Tri-County, exactly the same as Boulders, it sounds like. Will local city orders for shelter in place trump county and state? No, they will not. Generally speaking, our concepts of supremacy in terms of law, federal is going to trump state and state would trump local. So to the extent the state does something different, it's going to have an impact across all states regardless. And so there you have it there. So we'll see. And again, we're working to preserve it, but it's in some cases a more difficult issue at the state level than it is at the local level. Okay, please talk for a bit on clear policy in today's environment, clear cooperation. It's funny, the very next comment is a comment, not a question, from my buddy Greg Zadell, who's a former CAR chair and or CAR president and one of the all around nicest people I know. So he said no delay for clear cooperation policy at this time. For those of you who know Greg, he has been on the front lines of clear cooperation on all MLS issues for a long time, and is my go-to expert. So apparently at this point in time, NAR is not doing anything to delay their clear cooperation policy and the mandatory implementation date of May 1. So, and then thank you, Scott. Presentation rocks. Thank you, Amy. You're sweet. NAR, Greg also mentions that NAR is having a clear cooperation webinar on Tuesday, the 31st of March, I'm assuming, must be. So check that out on NAR's, and if you have a question, email me and I'll try and get you back information on a link. But if you look at NAR's website up in clear cooperation, I'm sure you'll find a link to that webinar, and I'd encourage you to go because it is an important. It's an interesting policy. And it's going to change a lot of the dynamics of how you guys do business, and so check that out. Thoughts on offer where broker and buyer near view property, but based on MLS photos, never view property. So Steve's asking about virtual tours and an offer where a buyer hasn't actually physically been in the property. Normally, my answer would be that seems a little bit crazy to me. In this uncertain time, uncertain circumstances, it seems to start making a little bit more sense to me on some level. I mean, I think you've got to be cautious. And if I'm a buyer's agent in that case, I'm probably going to be sending an email to my buyer to say, hey, listen, this is unorthodox. If you truly want me to present an offer on this property, even though we've never stepped foot inside of it and you're basing it strictly on pictures or a virtual tour or drive-bys or whatever, I think I would just do a CYA email from you as a buyer's agent to your buyer to say, this isn't normal course of business, but I get it. We're not living in a normal time right now. So, that would be the best way, I think, to do it. My normal answer would be absolutely not, but normal is they drove by my house several days ago at a minimum. Thank you for your knowledge. For those of us that saw it yesterday, what color are my pants? I showed you my pants already. Thank you for time. Effectively do the nice platitudes. You guys are so great. I can't tell you how much I appreciate the comments, and our staff appreciates the comments, and I know Tyrone appreciates the comments, and you guys are very, very kind. Showing a wealthy couple homes, they later call and inform me that they have the virus. Sellers contract the virus. I contract the virus. My spouse contracts the virus, passes away. One of the sellers passes away from the virus. What are everyone's liabilities? Again, I'm not exactly sure. Like I say, probably not. But the question, the core of that question goes to what is within your expected standard of care at this point as a licensed professional in Colorado? And I would say, at some point you say, I'm not comfortable taking parties into a home, or I'm not comfortable authorizing showings of my seller's home because of the risks associated with this. In a normal world, I'd say, well, that is, somebody gets some other virus or disease and they have damages as a result of that. Well, you as a real estate broker, I would say, don't have liability for that in a normal world, because who would have thought? I mean, what are the odds? It's a proximate cause is kind of the legal theory behind that. And that kind of goes to your standard of care. In this environment with, all you're being smacked with is COVID information, whether it's related to real estate or social distancing or shelter-in-place orders or everything else. In this environment, that answer probably potentially changes. And this is the core of what I'm getting to when I say you need to use your essential service powers responsibly. You've got to be more conscious than ever and think about what you're doing. So I don't know. That's another question that you're going to be asking a judge later, and that issue will turn ultimately on, was it within the broker's standard of care to have avoided exposing any of the parties to this? And normal virus, I don't think any way, shape, or form. This particular virus, maybe. Clear cooperation policy, a question on it. Check out that webinar. Thank you. Let's see. How do you feel about using specific performance clause in contract for buyers? I mean, I talk about specific performance. I don't know that it's a practical remedy for most buyers on a primary home situation in the event the seller is actually going to contest their performance, right? In other words, they're going to lawyer up and they're going to litigate it, because litigating a specific performance action is it's not going to take place in, in weeks or even months in most cases. And so I don't generally like it as a remedy. In this market, I think you also run the risk of going through all of that litigation, as I described before, if you're a buyer, only to find out the judge determines that it was based on the severity of the pandemic and the implications of the pandemic. It was reasonable for a seller to say, I'm not going to perform. And a buyer then loses a specific performance action. So avoid that. If you're representing a buyer or a seller, you're much better off brokering, using your brokerage and sales skills to keep parties together, to keep transactions together, and to give everybody a nice breath. Oh, nice comments. Thank you. Thank you. Let's see. Thanks for, you guys are so sweet. You always provide it. Oh, I believe realtors need to understand and accept that it is not business as usual. Yeah, it is not business as usual, David. And thanks for your kind remarks. And I hope you're doing well and taking care of yourself. All right, that's it. I'm done. I've answered all the questions. I now get to immediately transition to answering the hotline for the next hour. I'm only doing it for an hour this afternoon. So, but it is available again from 8 to 4 for this week and next week. And if we have to extend that out longer, then we'll do that. So hopefully this has been valuable and productive. And take care of yourselves. Take care of each other. Take care of expanding your value proposition. You are more valuable than ever in this current environment, but what you do in this environment is going to make you more valuable than ever going forward. So keep all that in mind, and I hope that that has been a good session for you. Take care, guys.